AP, test is coming up. Tested off the robe, and I figured maybe we could go over some Supreme Court cases, seeing how that's what the FRQs that you're doing for this week have to do with. And so we'll go over some of the more important ones. So let's get into the AP Gov, Important Supreme Court of the United States cases. So the court is like a silent referee, and you know when they use a capital C for court, that is the Supreme Court they're referring to. And the Supreme Court are not judges, they are justices. That's how you know the difference. And what they do is they'll watch and they'll listen, and they can decide to take a case or not, but they will not make a judgment unless they are asked to. So they're not activists, they don't go looking for a problem or looking for trouble. They wait until someone comes to them and says, I think my rights have been violated, we want you to rule on this. And this was probably on purpose, because when the Founding Fathers put the Constitution together with the three branches of government, they really wanted the judicial to be the least invasive and the least proactive, kind of as a last resort kind of thing. So that's why you're going to see them, you know, they're not rock stars and they don't get hurt a lot, but when they make a decision, it's a pretty big deal. So if we look into federalism and some of the earliest cases, one of the ones that stands out as probably the most important was Marbury versus Madison. So check out this soap opera. You have outgoing President John Adams had just lost the election of 1800 to Thomas Jefferson. He's not going to be leaving office until March. That's when the inauguration will happen, and that's when Jefferson, who was president-elect, is going to take over. So that means that Adams has a number of months to pretty much do whatever he wants to, or pretty close to it, to keep the Federalist agenda going. And one of the main things that he did, and you know, it was questionable at best, was the so-called midnight judges, meaning that practically midnight of his last day, he tried to appoint any number of federal judges, including to the Supreme Court. One of these justices was John Marshall. And John Marshall would become the Chief Justice of the Supreme Court during this time. Strangely enough, he's cousins with Jefferson, and they couldn't stand each other. Marshall was a Federalist, and Jefferson was a Democrat-Republican. So you would have thought that anything that went before Marshall and his court would have sided with the Federalist side, but there was one particular case that came up, and that was Marbury versus Madison, in where Adams had named or appointed William Marbury as a federal judge. And as you know, federal judge is in there for life. The problem was that Marbury never got the papers that he needed in order to be a judge. He literally had to have papers in hand. Well, when Jefferson went to the White House, his Secretary of State, James Madison, found the papers in a desk and refused to give it to him. He refused to hand the papers to Marbury so that he could be a judge. Marbury, as you can imagine, was incensed about this and decided to sue and took it all the way to the Supreme Court, saying that he deserved to have those papers to be a judge and that Madison was wrong for keeping it from him and the whole thing. The decision that the court made, and it's not nearly as big as the importance of it, but the decision that the court made was that Marbury could not be a judge, or at least it wasn't up to the Supreme Court to make him a judge. And for good reason. If you look at the separation of powers in the Constitution, the judicial branch does not have the power to create a judge. So therefore, the court decided to stand down, and he was going to have to get a job some other way. The bigger importance of this is that Marshall set the precedent for the Supreme Court to have the power of judicial review. And that's the importance of it, because if you look in the Constitution for judicial review, you won't find it. This case established it for the Supreme Court. And judicial review is the idea that the Supreme Court can look at an act of Congress or an act of the executive, and actually winds up being the states also by the time it's done, and deciding whether or not the acts of either one of the other two branches was constitutional or not. And if they deem it unconstitutional, that particular act or law becomes null and void at that point. So some other cases involving federalism early on. There was a case, McCullough versus Maryland, where the state of Maryland thought that the national bank was something that shouldn't be happening, that it was unconstitutional. And what they decided to do was to try to tax the national bank in their state so heavily that it would go out of business, that it would go bankrupt. So the national bank, led by McCullough, took it to court, and the Supreme Court ruled that Maryland was using the power of taxing as a way to destroy the bank, and that that was not okay with them. That the national branch, or sorry, the national government does have a right, does have some flexibility in making things like the national bank, and therefore it was okay. Woodward versus Dartmouth was another case where Dartmouth College had an early grant from the King of England before the United States existed, so that they could exist as a college. And the state of New Hampshire tried to take it back and tried to make this private college into a public college. And the Supreme Court ruled that New Hampshire was violating a contract that Dartmouth had and couldn't do it. Another one was Gibbons versus Ogden. This one's kind of interesting also, in that one had a right, or had permission to run a ferry between New York and New Jersey on the Hudson River. So if you look at the map here, this is Manhattan, and down here would be Brooklyn. But across the Hudson River, this is the Hudson River running here, is New Jersey. And both Gibbons and Ogden had a ferry system to bring people back and forth between New York City, you know, mainly for work, because the bridges didn't exist during this time. There was no Brooklyn Bridge or tunnels or anything like that. So that was the main way for people to get to the city and back again. Gibbons didn't like the fact that Ogden was taking his business. Gibbons had, if I remember, if I'm getting this right now, because I always get this confused, but Gibbons had a state of New York license where Ogden had a federal license. So Gibbons took Ogden to court, saying that Ogden could not run a ferry business against his. And the Supreme Court ruled against him, saying that because this river runs between two states, that's interstate trade. And if it was just within New York itself, that would be fine. But because this river runs between two states, it's interstate, and that becomes a federal thing. Maybe more importantly, in each of these cases, the Supreme Court ruled on the side of the federal government over the state, and was really making the federal government the more authoritative part of the government going forward. It set the precedent for a lot of things going forward. Now, surprisingly, the Constitution, when it first came about and the Bill of Rights were passed, the Constitution does not have wording that forces the states to follow the Bill of Rights. That wouldn't happen until after the Civil War, when the 14th Amendment happens and the Incorporation Clause takes a hold. So every time something came up, a particular state could potentially violate your freedom of speech. It could violate your right to bear arms, or so on and so on. So in order for anything to happen after the 14th Amendment was passed, you would have to question a state court decision and bring it to the Supreme Court. So for years and years and years, there could be violations of rights that, you know, nobody did anything about because they never questioned it. You had to be willing to question it. You had to be willing to get a lawyer. You had to be willing to go to the Supreme Court, and then hope to God that the Supreme Court listened to your case. So here we have some important First Amendment Supreme Court cases, like Schenck versus the United States. That was during World War I. Gitlow versus New York, and Tinker v. Des Moines Independent Schools from 1969. The Schenck case is usually the more famous of these cases. During World War I, there was a number of people that were anti-war. Schenck was one of them. And he was passing out anti-draft leaflets, trying to get people to not go to the draft for military purposes when they were called. And he was arrested for this, and he was fined for it. And so he took it to the Supreme Court, saying that my First Amendment rights have been violated. And the Supreme Court disagreed on the idea that there was a clear and present danger with World War I, and stopping people from going to the draft was a danger to our society, a danger to our country during a war. The Gitlow case was was along the same lines. It was 1925. Gitlow was a socialist who was advocating the overthrow of the government, and the Supreme Court did not back him up on this. They upheld his conviction, saying that because he was advocating for the overthrow of the government, that he did not have that freedom of speech. Tinker was 1969, and it had to do with students, I believe in 8th grade, that were wearing armbands that were in support of the anti-war movement. This was important because the armbands were a symbolic speech. In other words, the students weren't really saying anything, but they were wearing something that held some symbolic relevance. And they were suspended for it. The principal and the school system didn't want that kind of distraction. So they took it to court, and the Supreme Court backed them up and said, no, they have every right to have those armbands on if they want to. As far as Fourth Amendment is concerned, search and seizure, the main case that usually comes up is Mapp versus Ohio. This has to do with a woman in Ohio who was involved with a man who was known for gambling. And so the police were after him, and they tried to get into her house to find evidence against him, and she refused. And she said that they needed a warrant. So they came back with a piece of paper, which wasn't a warrant. They claimed that it was a warrant. And they busted down the door, and they found all this evidence about his gambling, and apparently found some pornographic materials, and they took her to court. And the Supreme Court said that none of that could be held because it was in violation of the Fourth Amendment, that they did not have an actual warrant that would allow them to use any evidence against her at that point. For the Fifth Amendment, the main case that comes about is called Miranda versus Arizona. And this is where Miranda rights come from. So I'm looking in this document. In Miranda versus Arizona in 1966, the Supreme Court ruled that detained criminal suspects prior to police questioning must be informed of their constitutional rights to an attorney and against self-incrimination. The case began with the 1963 arrest of Phoenix resident Ernesto Miranda, who was charged with rape, kidnapping, and robbery. Miranda was not informed of his rights prior to the police interrogation. During the 2-hour interrogation, Miranda allegedly confessed to committing the crimes, which the police apparently recorded. Miranda, who had not finished 9th grade and had a history of mental instability, had no counsel present. At trial, the prosecution's case consisted solely of his confession. Miranda was convicted of both rape and kidnapping and sentenced to 20 to 30 years in prison. He appealed to the Arizona Supreme Court, claiming that the police had unconstitutionally obtained his confession. The court disagreed and upheld the conviction. Miranda appealed to the U.S. Supreme Court, which reviewed the case in 1966, and in a 5-4 decision, ruled that the prosecution could not introduce Miranda's confession as evidence in a criminal trial because the police had failed to first inform Miranda of his right to an attorney and against self-incrimination. The police duty to give these warnings is compelled by the Constitution's Fifth Amendment, which gives a criminal suspect the right to refuse to be a witness against himself, and the Sixth Amendment, which guarantees criminal defendants the right to an attorney. A famous Sixth Amendment case was Gideon v. Wainwright. So Clarence Gideon was kind of an interesting guy, pretty harmless, probably not the most intelligent person on the face of the earth. And he was accused of breaking and entering a pool hall in Florida and stealing money. And he tried to tell the courts of Florida that he didn't have the money to have a lawyer. And the court said, well, you know, it's only special circumstances that you need to get a lawyer from the government, so too bad. And so they found him guilty, and he went to prison. And he started looking into some law books and realized that he probably had a case. So he went all through it by himself, went through the whole procedure of applying to the Supreme Court and getting them to take his case. And they even found some lawyers pro bono, which means that he was going to get some good lawyers for free to take his case. And the Supreme Court found in his favor, saying that he had a right to an attorney and money should have nothing to do with it. So they forced the Florida Supreme Court to force the Florida District Court to retry him, and he was found innocent of the crime. There have been any number of cases dealing with the Eighth Amendment, especially when it comes to the death penalty, but the one that usually gets brought up is Gregg v. Georgia. To put it simply, Troy Gregg was found guilty of armed robbery and murder and sentenced him to death. And he said, well, that's cruel and unusual punishment based on the 8th and the 14th Amendments. And the Supreme Court said, nope, it's not, and we're going to kill you. That was it. There is a case involving the 9th Amendment, which is kind of interesting, called Griswold v. Connecticut. And this established that the right to privacy is found in the 1st, 3rd, 4th, and 9th Amendments. This is kind of interesting because if you look for privacy in the Constitution or the Bill of Rights, you don't really find it. So you have to kind of find it embedded in other things. The case primarily was a woman that went to Planned Parenthood with her husband, trying to get advice about having a child or not, and whether or not to get contraception. And they were fined for it. The state found them in violation of some laws that they had. The state at the time had laws that banned contraception. So the idea that this married couple would choose to use contraception violated that rule, and they were fined for it. And the Supreme Court said that, no, that violates their right to privacy, especially with the 9th Amendment, and therefore they couldn't be held responsible. There's any number of civil rights cases that come up also, but the progression that's usually talked about when it comes to government is the beginning with Dred Scott versus Sanford, then leading to Plessy versus Ferguson, and then eventually Brown versus Topeka Board of Education. And it starts with the Dred Scott case. The simpler version of the story is that Dred Scott and his wife were slaves, and the owner took them from the southern state where slavery was allowed into a northern territory for a while, and then back again. And when the owner died and the owner's son tried to take ownership of Dred Scott and his wife, they tried to sue, saying that they had been in a free territory and therefore they themselves should be free. The courts at the time, this is before the Civil War, obviously had their own ways of looking at things back during that time. And they said, there's two reasons why we're going to rule against you. Number one, on a technicality, you are not a citizen. But second of all, you're property. And according to the 5th Amendment, property cannot be taken away without due process. And there was no reason to take property away from this person. So therefore, he was denied in both cases. With Plessy versus Ferguson, we jump ahead to the 1890s. Homer Plessy, and you can see him over here, was 1/8 African American, and he was purposely trying to challenge Jim Crow laws about trying to keep separate but equal facilities. And in this case, they had to do with train cars. So he got on a white train car when he, according to them, should have been on the black train car, and made it known to everybody that he was black, or at least 1/8 black, and he was arrested. And the courts took it in, the Supreme Court listened to it, and they said that, according to their beliefs, that the idea of separate but equal was fine, that you could have separate as long as they were equal facilities. And that leads us to Brown versus Topeka Board of Education, 1954. And this is the big one. It pretty much overturned Plessy versus Ferguson, which the Supreme Court hardly ever overturns its own rulings. They have something called stare decisis, which means that let the ruling stand, that if it's been decided before, that the courts will continue to abide by that ruling. But in this case, they thought that things had changed, that times had changed, and separate was inherently not equal. That if you went to any white facility versus a black facility, the white one would always be better. The white water fountain would always be better than the black one. The white restroom would always be better than the black one. Schools and so on. Brown wanted his daughter to go to a white school because it was a better educational opportunity. So Brown won the case, and that would begin the beginnings of desegregating schools in America. It would lead to the Little Rock 9 case. It would not be an easy battle by any stretch. Military was going to have to get involved any number of times. One of the main lawyers involved was Thurgood Marshall. He would eventually become the first black man to be on the Supreme Court, which which was an interesting twist. And then finally, when we get into abortion, Roe v. Wade is the big one, obviously. And pretty much what that said was that a woman has the right to make a private decision on whether to terminate a pregnancy or not. That a state, and this goes back to the 14th Amendment again, that the state does not have the right to take that right of privacy away from her. It also made it easier for a woman to get an abortion at a clinic instead of trying to either do it themselves or have somebody that doesn't know what they're doing do it. So it was safer. Over time, more cases were going to come down that would restrict it even more, because the Roe v. Wade case did make it so that you could get an abortion during the first trimester. There were some restrictions on the second trimester, and then the third trimester was off limits altogether. But more cases would come down the line that would restrict it a little bit more. And with the Supreme Court becoming more conservative in this present day and age, it wouldn't be unheard of for Roe v. Wade to be brought to the Supreme Court again, to have abortion rights challenged. And you may see in your lifetime this case get overturned. It's possible. So keep your eye out on that. So there's any number of cases that we could be talking about right now. This is just a review. I was hoping to just kind of bring it back to the forefront, things that maybe we talked about before. Do the FRQs. Those are coming straight from AP. It will probably give you a decent idea of what might be on the test coming up. So again, I hope you guys are doing well. I get dressed up just for you guys for this. Material, you can laugh at me all you want. It's fine. I love doing this. So hope you guys are doing well, and I'll talk to you soon.